Уважаемые коллеги,
Distinguished colleagues, ladies and gentlemen, good morning. Probably yesterday's gala reception was quite tense and fruitful from the viewpoint of communication in this wonderful city. So today not everyone is ready to start working at such early hour. The more so that many of my colleagues recognize that the forum in St. Petersburg is not only a possibility to work, but rather a possibility to have a rest, and we are lucky with the weather. Nevertheless, let us start our discussion. I think that we have a very interesting and provocative theme. This morning I was thinking, with what other legal institute could we compare the notion of a public-private partnership, which is also a legal institute, but its definition is not given now regulatory acts. Why? Of course, it is a bad comparison. I just recall the notion of corruption, though this is not what is typical of the PPP Institute, quite the reverse. It is on the other pole. Our institute of the Russian PPP is quite young. It develops quite quickly and it becomes quite fashionable. Many people are using it not in accordance with the purposes for which it exists globally. Therefore, it is very important at present that we lawyers could clearly understand that the Institute of Public-Private Partnership is targeted at the public benefit, which in Russia has a lack of financing. I primarily mean the infrastructure related to transport, engineering, social infrastructure. Therefore, it is important for us jointly to perceive this institution as a legal institution, as an institute which is aimed at justice and just and objective distribution of the risks, so that business and the authorities would objectively putting the efforts into the project help to attain the public benefit, the public welfare, in such a situation when both the state would get the relevant benefits from this communication and the business would have guaranteed conditions that would be just and equal for everyone. Today in our discussion we're going to have a great number of participants who might tell us about the situation abroad, and those specialists who are directly, theoretically and practically involved in development of the PPP Institute in Russia. And first, I would like to give the floor to Alexei Zverev as a person who probably combines several unique qualities and take such a position when both on behalf of business and on behalf of the authorities. He is helping everyone who would like to develop PPP Institute and attracting private funds to the infrastructure. He has a unique experience. He is a member of a great number of different working groups and teams of specialists, and he actively participates in preparation of different regulatory acts recommendations which make it possible for the PPP Institute to develop on the basis of the experience which is available to EBRD and other countries. So Alexei, you can take the floor, and I suggest that you will carry on this format. And we will answer the question that is formulated at the very beginning. To what extent the PPP Institute has got development prospects in Russia, and how it would differ from what they have in other countries of the world, and what is currently happening with financial markets. I think we can also ask these questions to you at any time, and you will be ready to answer them. Mr. Chairman, ladies and gentlemen, good morning. Thank you very much for the opportunity to take the floor, and thank you very much for the invitation to take part in St. Petersburg Legal Forum. I can just combine the things that cannot be combined. I would like to work hard during these 2 days to prepare. I have prepared, as you've seen, and I have brought a lot of materials to make a presentation and to respond to your provocative summons, so that our discussion would be interesting today. And I would like to combine it with what we have been discussing at the very beginning, to see the beautiful sights of St. Petersburg on these May days. I would like to start with the following. Instead of giving an answer to the question concerning the PPP prospects in Russia, I would like to ask my colleagues, particularly those who represent the UK here, I would like to ask a question which is directly related with the theme of our today's discussion. Probably I will ask that question directly in the English language.
Ask you a question. Okay. Since you are British, do you know what is the most popular name? What has been the most popular name, given name, that parents choose to give their children in the UK?
I'm afraid not.
James?
John.
John. Я перехожу на русский язык.
Now I switch to Russian in order to answer this question. In fact, in the UK in the last years, the most popular name was Muhammad, not John and not James. Why is this directly related with the theme of our today's discussion? Times are changing and the world is changing, and 20 years ago, the concept of PPP came into the world. It first didn't originate in the UK as we commonly believe, but that was in Australia in 1979. The first document was drawn up on PPP. However, the British people in 1992 carried on this idea and developed this instrument, and the then government of Conservatives, the government of John Major, opposed that concept and put it on the rails of a conveyor, actually. Why? Because within 20 years, multi-billion projects were successfully implemented. Of course, there were projects that were not quite successful. They were successfully implemented in Britain based on public-private partnership principles. 5 years later, in 1997, when the Conservatives were superseded by the Labourists, and the government of Tony Blair also carried on this idea, the emphasis was shifted. In 1992, initially the purposes that were formulated by the British government was to reduce the time, to reduce the burden of debts on the budget. In 1997, their purposes have altered, and the cornerstone was the efficiency, what is called value for money. I'm speaking about it because the purposes which are put by the body that formulates the policy of private-public partnership is of utmost significance for understanding what is being done, how it is being done, and what is the purpose of this. Analyzing the generation of PPP in the Russian Federation, I came to certain conclusions which I would like to share with you now. In 2005, when the law was drawn up on concession agreements, it seems to me that the main item was not the principle of efficiency and not the principle of reducing the burden, that burden on the budget. Frankly speaking, I don't know what was the main thing, and later probably I will ask Alexei, or I can ask this question now. I hope that is not the question that would call the authors to the stage. Is there in St. Petersburg a clear legal policy, what is called policy, the strategy of development of PPP at the level of a region? However, we can discuss it a bit later. I believe that what happened in 2005, proceeding from the law on concession agreements, speaks for itself. The law, unfortunately, regulates only one form. What is the reason for that? In the Russian Federation, there was an investment fund, and the money of that fund had to be spent. As to how the money should be spent, efficiently or non-efficiently, whether the PPP projects will be completed on time, within the estimated cost, I mean the question of efficiency, that was not the greatest concern either of the legislation or the legislators or those who formulated the PPP policy. So unfortunately at the federal level only one form is regulated. Therefore, like mushrooms after the rain in different regions in the last 6 to 7 years, there appeared the legislative movement which generated the following. 36 regions have regional legislation on PPP at present. We're going to come back to it later. As far as I understand, I have got some 3 to 5 minutes, and I would like to say a few words about the European Bank for Reconstruction and Development, what we are doing. For those who are not quite familiar with our activity, European Bank for Reconstruction and Development, starting with 1991, exists on that stage. It is the largest investor practically in all the countries where it operates, in the countries of Central and Eastern Europe, the former Soviet Union, and now, since last year, it has been also operating in North Africa. In the last 20 years, we participated in more than 40 projects on PPP, starting with 1993. The smallest project amounted to 9 million euro. I'm speaking about it because commonly the projects are much larger. Nevertheless, we had such experience. In addition to participation in the project, as was correctly mentioned by Alexei, the European Bank for Reconstruction and Development is also actively involved in formulating the standards of the best practice in the sphere of concessions and public-private partnership. For instance, we have developed a document that is called Key Principles of Modern Concession Legislation. It is displayed on our site www.ebrd.com/concessions. Generally, this site contains a lot of different documents which can be helpful to legislators and practitioners and to the official persons, to the officials. They might be quite helpful. Besides, I also participated in the working group of the UN Commission on the International Trade Law, UNCITRAL, which in 2003 at UN a model law was passed on transactions, infrastructural transactions financed from private sources. So this is another definition of a PPP. As to the definition, actually, until recently, there were very few definitions or very few documents where you could read the definition of a public-private partnership. What was the reason for that? I think that unlike, for instance, concessions, which is a legal term, the term a public-private partnership is most likely not a legal term, but a term of a legal policy, and most often this term is defined or described in the conceptual or strategic document which is adopted at the level of the government in the non-normative document. In Russia we don't have such a document, so I cannot refer to it. However, such documents are quite numerous. I have been mentioning the British documents which are issued by the Treasury. So in many countries they have got such documents. Probably the most interesting and the most extensive document was issued in Latvia in 2005. In Quebec and Britain, in Ireland and so on. It seems to me that in the Russian Federation it would be possible at the level of the government to draw up such material so that will send a signal of the political will, the signal that will be circulated globally to the potential investors and to potential financiers, so that in the Russian Federation public and private partnership will develop. It will develop on the following principles and so on. This is not a legal material, so we shouldn't mix it up with the different laws and acts. Whether it would be reasonable to speak about the disadvantages of current legislation, I think it should not be done, because this is a legal conference and the audience are lawyers, so there is no sense of talking about it. Of course, there might be some questions and we'll discuss it afterwards, but the question which I would like to address to Alexei, I would still like to ask. Before answering your question, I would like to ask you, and I'm planning to ask this question to everyone, from your viewpoint in Russia, the Institute of Public-Private Partnership, will it develop not only on the basis of debates? Are there any prospects for development as it occurs in other countries? Or Russia will, as usual, take its own trend, or do you think that this is something special? Specific features are recorded everywhere. Otherwise, it would be impossible to exist or survive, taking into account the specificity. I think that there are prospects, and today's situation clearly shows and clearly illustrates that there are prospects and there are good prospects. As for the specific features and as for the status at what stage of development in the Russian Federation the legislation is at present, let us analyze how regularly amendments are made to the federal law on concession agreements adopted in 2005 at least once a year. I have some information on days 5th, 6th, 7th, 8th, 9th, 11th, 12th. So each year without exception. You can draw your conclusions, but from the very beginning, everyone pointed to certain disadvantages, but of course there are certain advantages as well. The thing is that from the very beginning, I think not a reasonable choice was made as regards the definition of the concession.
As is known, the definition of a concession in Russia is different from the definition that is used, for example, in Europe. Concessions are described through objects and assets, but not through provision of services and performance of works. So this reduces and narrows down the area, and legislation focuses on the issues of construction, but services and maintenance component is forgotten. And secondly, a very important characteristic of any PPP project is orientation towards the final product. It is qualitative characteristics of what we will get in the end. And this what makes PPP different from regular public procurement. In the Russian Federation, unfortunately, right now, this maybe it is due to its preparation, maybe lack of qualified specialists, but key parameters, key indicators, key performance indicators, they are still at the very initial stage of development. So there's no question about there's nothing about related to output-based projects. So, and this is due to the fact that from the very beginning, the law was aimed or focused on distribution of funds from the investment fund. So the emphasis is made on how much will be brought by a private investor, but this is not the core of PPP projects. Thank you. Now I will speak briefly about the issue you formulated, the policy of St. Petersburg government, and using PPP projects as something to improve infrastructure conditions. You know, it's been for a long time that when we have many things, very good things on paper, but in reality we don't. We have discussed prospects of St. Petersburg development for the period 2020. Yeah, the strategy of development is changing, it is revised, but still, business people keep saying, so you, the government, you make a final decision. What is the main strategy? So now the latest version of the strategy is approved, and there are 5 priorities in the area of economic and social development, and this will be used as the basis for action plans and also to attract investments into these areas. And this strategy contains the words about PPP, that this is a mechanism of attracting investments into these priority areas for St. Petersburg. But a major, or in terms of policy, PPP policy, you won't find anything else. That's the only thing we have. We are proud of being project-oriented administration, and the number of projects that exist or are being implemented in Russia, half of them are in St. Petersburg. And I believe it is important to focus and stress that we here in St. Petersburg, as lawyers, we understand PPP as a contractual PPP, because in other entities of the Russian Federation, they call anything PPP when the investor participates somehow, when the administration, for example, prepares the site and provides utilities, and then the private investor builds something on this site, and then they call it a PPP partnership. And I believe we need to divide, because politicians speak about PPP, and this is not a legal term that they're using. It's just interrelations between the authorities and business. And the second meaning is a legal perspective. It is here we speak about contractual relations, agreements, and risks distribution. And of course, we as lawyers, we all understand it, but people from the business community and public authorities, we every time have to clarify that this is slightly different. Maybe it's not 100% legal, it is more of an economic nature, but we always have to keep this in mind. We need to understand exactly what we mean when we speak about PPP. I believe now we can change the sequence of the speakers slightly, and I'd like to give the floor to Fyodor Tisolkin, who is a practitioner, and he is quite short of time because he's very active and he's very busy, and so he has to take part in negotiations, because there are negotiations between the government of St. Petersburg and the Western high-speed diameter project, the winner of the tender for that project. So further, I'd like to give the floor to you now, how you view this area. Thank you, Alexei. Yeah, it is. Yeah, I appreciate it, because you could actually keep me here, and then the investor's position would be stronger. Sorry, is there a microphone that I can use somewhere else, because I don't want to be sitting in the corner?
Так, вот теперь, наверное, работает. Ага. Спасибо большое, всем добрый день. Я представляю компанию Freshfields. Так сложилось, что в большинстве крупных проектов ГЧП, которые реализовывались в России, мы так или иначе на той, другой или третьей стороне участвовали. И как раз сегодня я хотел бы попробовать за тот регламент, который у меня есть, ответить на два вопроса. Во-первых, что поменялось в России за те годы, в течение которых проекты ГЧП и концепция ГЧП существует. И, во-вторых, что нужно сделать, по моему скромному мнению, для того, чтобы то, о чем говорил Алексей, перспектива российских ГЧП была бы еще более радужной. Алексей говорил в своем выступлении, что действительно где-то с середины 2000-х годов в России зародилась концепция ГЧП, но так сложилось, что вот мы стали заниматься темой ГЧП где-то с конца 90-х. Этот парадокс, такой кажущийся, объясняется очень просто. Где-то действительно в это время, в конце 90-х, иностранные инвесторы, прежде всего немецкие, австрийские, совершенно, так сказать, независимо от общефедеральных законодательных политических тенденциях, начали реализовывать инфраструктурные проекты в Москве прежде всего. Вот там мы как раз инвесторам помогали, и примерно в это же время, вот в начале 2000-х, крупные скандинавские инвесторы, консорциум в Санкт-Петербурге, договаривались с администрацией, реализовывали проект юго-западных очистных сооружений. В прессе и в таком общем понимании, что ли, эти проекты часто называются прото-PPP, потому что, ну, действительно, наверное, то распределение рисков, которое существовало в этих проектах, те платежные механизмы, которые там фиксировались, они довольно сильно отличаются от того, что мы видим сегодня в крупных сделках. Сегодня, конечно, это гораздо более приближено к международным стандартам, но, тем не менее, суть отношений от этого не меняется. Это действительно частные, международные инвестиции в инфраструктуру, которые предполагали механизмы проектного финансирования. Поэтому и по коммерческой составляющей, и, что нам всем более близко, по составляющей контрактной, юридической, это можно вполне было называть государственно-частным партнерством.
And public partnership. And up to 2005, all that was implemented within the federal laws, and with all those limitations of the federal law, we see that regions most advanced, and St. Petersburg is among them, they try to implement these large PPP projects not within the not under the federal law, but under the regional laws, and from the civil law perspective, actually the major principles, they are in the civil code, and the experience that we have had for more than 10 years, it becomes very useful. And the impulse that was provided, that was both legal, legislative, and in December 2006, the Russian regional law was issued. Then there was that federal law, and of course there was a financial impulse, and I mean the investment fund, and of course there is a political impulse as well. And if we think about major players, major stakeholders, there were many foreign companies and banks. There were largest construction companies and all major companies. They all visited St. Petersburg, and they all were somehow involved in those transactions. Strabag, Vinci, Buick, and so on. Then international banks, development banks, and also some of commercial banks as well. They also were interested. Now we see, in the last few years, we see another trend. This is nationalization, not in the strict legal term. Nationalization of the Russian PPP market, and the main role is now played by Russian companies and Russian banks. This is due to various reasons. Definitely There are political, business, financial reasons, as we know, neither on the federal level or the regional level. The state cannot bear the foreign exchange risks and the equity of the players who have a lot of ruble liquidity, so they play the main role and they bring some foreign investments, but the major role is played by the Russian institutions. And going straight to the second question, what about future prospects of PPP? As I said, the Russian players play a very important role, and I'm very happy to be a consultant for many of these projects. I believe that in the strategic perspective, Russia and Russian regions definitely need to consider mechanisms that allow to change this curve of nationalization and internalization. So we need to be more open to foreign investments. And yeah, there are again pure financial issues of forex risks, but also there are risks of preparation of projects and transparency of strategic planning. So what Alexei asked about the program of PPP, yeah, this is a key issue. So it's not by chance. Yeah, and I believe this is one of the key elements of the Russian agenda currently. Russian investors have their own ways of getting information. Yeah, they are more informed about what is happening in different regions, in different industries, if we speak about federal projects, and they get a better feeling due to their contacts where there are some prospects or not. But the task of the government is to make this information available, to make it open to the market and involvement of major players in competitions, in tenders for PPP projects. And I know myself people who were involved in several projects. I know some operators and construction companies. Some of them, again, due to a number of reasons, partly because of the crisis that actually hit some of the projects, but first of all, because of those transparency difficulties, they feel somewhat disappointed. I don't think that this disappointment is critical in a strategic sense, but we need to be very active. We need to position Russian regions actively as an open international market for such projects. We all know that the key success factor of a PPP project, especially for the government, is competition. The process of PPP projects is quite complex, and for example, if we compare public procurement, where everything is clear, there's a contract, clear terms and conditions, and then we just looking for the price. No, if we speak about PPP project, no, it is more complex. There's always a political pressure to make it all faster, but it is always a negotiation process, and there are several parties to this agreement. And the only thing that can make the government side more stronger is to have a wider competition. And for this, we need to work with the market more actively at the preparation stage, and I'm happy to say that projects that are being implemented right now, for example, the Neva water project, it's a recent project, they take into account the experience and all lessons learned during the previous years. And there are 3 major international players involved in this project, and I mean these are construction companies and operators, international operators, and they compete, and this is very good. Okay, I'll try to be brief because I'm aware of the time. So could you please move on to this next slide? Thank you. Actually, I've mentioned this briefly already. Models, PPP models. Yeah, definitely the spectrum is becoming wider. If the first models were based, or the first projects about 7 years ago, they were based on the concession law, federal concession law. Yeah, definitely. This is a federal act that creates a clear legislative time frame, legislative framework. But what is important for the banks? But federal law provides only one form, and there are no ways of providing additional guarantees to banks. And the federal law limits the rights which are gained under the concession agreement, so they cannot be transferred or sold. Then again, there are some other limitations related to the tender procedure, because it is not possible to evaluate non-financial components of bids. So, and you see the Pulkovo project and the Western Diameter project in its current form, the Neva water projects, they are now under the regional law, and there are elements of private property or some other rights of the private investor. And we know that these models will be developing, and this list will be expanding. After is developing a number of projects, and there will be a long-term operator agreement, and it is different slightly from a concession agreement because the volume of investments is different.
The sense is not in building a road because it is available, but some added value to that road should be added. For instance, it would be a toll road if traffic is organized, and then it is necessary to efficiently, in accordance with the national international standards, to operate the road. Next slide. Payment mechanism. At the very beginning, I mentioned that the projects that were implemented from 2005 differed from payment mechanism as compared to the present project. Then the state was paying on a prolonged basis for the infrastructural project that was, so to say, the element of a state contract or state order. The investor receives financing himself as soon as he constructs the object at the stage of operation. The state, by equal parts within 10 to 15 years, will pay back the investment. Then the risks of construction and operation were separated. Whatever happened with the facility during operation, what was the quality of this operation, whether the facility was destroyed due to force majeure or some other risk, the obligation of the state was abstract in that respect. The present payment mechanisms are quite different. We can see a lot of examples of the so-called real toll, when the investor fully assumes the risk of demand and receiving nothing from the state as a fixed payment for the construction and operation, and all his investments would be repaid due to collecting money from the users of the facilities. Some of the projects involve even quite extensive concession payment, so to say, backwards. The investor pays to the city or to the state. For instance, Pulkovo project, as a profitable international airport, this was the first scheme. There are schemes of pure rail toll, federal highway M10 Moscow St. Petersburg, No one doubts the forecast of the traffic. You can just see how what is with the exit along Leningradsky highway from from Moscow. There are some mechanisms available at the Russian market where the state guarantees a certain profitability or certain revenues. The investor collects the payment. If it collects less than a certain threshold, the state would pay additionally, and the Western high-speed diameter is based on this scheme. There is a scheme when the state pays a fixed payment for the service and separates the investor from the risks on collecting payments, demands, and tariffs, and so on. For instance, water projects are commonly have these bases. Probably never water will follow this trend as well. Next slide. Move on, please. Next slide. Yes, thank you. Will you please come back to the previous one? Another trend: enhancement of the position of the state in these projects. We don't mean the strengthening that would undermine the interests of the private investor of the project, but most likely greater knowledge and experience is available to the public players, and this knowledge is taken into account in the contract documents and how the state approaches the project. In the slide you can see that it includes different aspects and mechanisms, including the control mechanism over the projects. I would draw your attention to bullet point last but one, how it might often happen at the market where the process is just generated, the recipient, the banks that participate in the project finance the greatest debt in such transactions. Initially they proceeded from the concept of the so-called 100% reimbursement. Whatever happens in the transaction, whether the borrower or the state would be to blame, or probably there would be a force majeure situation, banks, due to the collaterals they have, due to the compensations from the city paid at the completion of the project, they receive 100% reimbursement together with all possible interests that are due to them after the credit documents. Strictly speaking, this is not their position, which is typical of the bank of project financing globally. These are banks of project financing since they assume the risk of the project. They do not credit a large company with an extensive balance or some. They do not credit the state or sovereign rating. They are just crediting the project, and their task is to control the implementation of the project, being sure that everything is normal from the viewpoint of financing, engineering viewpoint, and legal viewpoint. If they do not work properly, if the project fails, they will incur certain losses. Gradually in Russia this concept starts to take root, and banks, both Russian and international, gradually start to take a hit or agree of assuming a part of that shock in case of a negative development of the project that is highly important. Move on, please. And concluding my presentation, I have already mentioned some issues that seem quite important for me. They should be taken into account for further development of the PPP. Probably from what I have not mentioned, there are two items. First, legislation. Naturally, being lawyers, we have a lot of claims to the current Russian legislation. The federal and concession legislation, though it changes each year, quantity doesn't often pass into quality. Sometimes the situation is quite the reverse, and the specific feature of the Russian legislature is, according to the words pronounced by Chernomyrdin, who wanted to have it better, and it appeared as always as to direct agreement crediting banks and the state conclude with involvement of shareholders a direct agreement which assumes that the banks or the state cannot cancel the concession agreement even if it has such right according to the concession agreement without offering to the banks to save the project, and that salvation is related to different collateral mechanisms that can be realized in that case. This is a very important concept, otherwise PPP would not work without it. Nothing was said in the concession law about it, and for many years Alexei and other representatives of EBRD and international financial institutions and generally the expert community explained to the federal authorities, to the legislators, that something has to be adopted. In one of the amendments, the notion of direct agreement appeared, but it was said that this direct agreement can be concluded only with one creditor, so only one. Where from, why, who invented it, it was not clear. Not a single transaction in which I participated was financed by only one creditor. We mean about hundreds of millions or billions of dollars or euro. And this is also with a consortium. The consortium, of course, is represented by the agent. One signature from the banks is on that document, but these are agency relations, and legally each bank is a party to that agreement. In these legislative matters, it is quite important to have a realistic approach to what we can and what we cannot do within the frame of the legislation. When now the ideas of the federal law and PPP are actively discussed that will cover all the possible models, not only the concession, I try to be very careful approaching this idea with a well-known medical statement. It is best of all, it is not to harm, because if this law is adopted, it will eliminate the regional legislation, and we don't know what would be its impact on current project. Probably the impact would be negative, and the prospects are not quite clear. Though the regional laws have their different difficulties, some things cannot be regulated at the level of region, land, budget, relationship with the state order, competitive procedures, and so on. We have to find some interpretations of the federal law, and they can be found in the bankable form. Even such conservative market players as the international financial institutions assume these interpretations and confirm the validity of the schemes. For instance, Pulkova in February 2012, there was a real and final financial closure when the banks issued the first tranche on the major credits, and that means that all the entire legal scheme has been confirmed as operational for them, and the banks are quite serious, EBRD, IFC, and many other banks. And the last item, as regards the legislation, despite the fact that there are some problems related to legislation, this is not the main problem of market development. The key challenge, in addition to the structure of the PPP unit, is the strategy of development of PPP and PPP units. This is the quality of the projects. We constantly come across the requests and the applications primarily of the regional administrations or players. They ask us as consultants and say, just we have a project, let us do it in such a way that in half a year we start construction, because the city is being suffocated. We need to expand the airport or to build a highway. They show 3 papers to us to our colleagues, financial consultants, engineering, technical consultants, you're experienced people. This is an approach which kills PPP. The state should be quite realistically assessing the time period. We understand that the preparation of a serious PPP project needs just 2 or 3 years until all the contracts will be concluded and construction may start. Sometimes it is less, but more often it is longer. That is an objective reality. If the state needs to have it quicker, a model of the state order should be applied, which is quicker and simpler. Then this state wouldn't get some benefits as it would receive in case of a PPP. We have to determine if it is a PPP. We should have a serious approach. Thank you. Further. I'm asking only one question. You said you mentioned the problems that interfere with active growth of PPP, and the main problem was transparency, so that the foreign players, which for the first time were quite happy and enthusiastic as regards the process. Now you are feeling that the transparency is diminishing and more Russian players are entering the market, and they have certain advantages as regards understanding of what projects might be implemented in future. Do you think is there a potential for foreign players without Russian partners? Is it possible that a foreign player in the open situation, when he knows 10 years ahead about the project of Avtodor or government of Moscow related to PPP, he will be able to prepare serious competitive participation in such a project without the Russian player? Thank you, Alexei, for your question. That is a very topical question. I think that all the serious international players at the market that have been considering Russia for a certain time, understand that without the Russian partner they won't be able to survive. And the reason of that statement, among the reasons of that statement, are some reasons from which we would like to eliminate all of us. These are not only the problems of PPP trend, but the general problems of the Russian life and economy. Sometimes it is difficult and quite peculiar, and we have to cope with these peculiarities gradually. However, there are some objective things which, even in the most transparent and distilled environment, will be retained. There are some features related with construction and designing which are known only to the Russian specialists and the Russian building companies, and there are some specific features related with financing and liquidity, zero liquidity, and to all these questions we can say that we can have a subcontractor who will give know-how to the major international player. You can always use some mechanisms. For instance, I knew that EBRD some time ago planned a major to raise the liquidity, ruble liquidity by means of treasuries. There are some mechanisms that the international players can do it, but it is easier to do it with the Russian player. Nevertheless, I think that the index of competitiveness, even if the international companies are not coming independent, there will be the possibility for the international company to come and to win. Of course, a serious player, a reasonable player, will come jointly with someone, but this participation should not be forced, not related with the fact that a person with whom they participate has special contacts or possibilities. It should have an objective basis. Then, from the viewpoint of mutual relations between these partners, and you know well enough that relationships between shareholders in such transactions are a very complicated theme. My colleagues who are actively dealing the so-called agreements of action as SHE said repeatedly that in your PPPs TSHG, TSHG that we prepare for the clients within the entire package of services probably is the most complicated object. Unlike the situation of pure business when the shareholder can just withdraw from their projects, project financing and concession impose on these shareholders obligation on retaining their share in the project. Otherwise, there will be a default or cancellation of the concession agreement, and that means that this SHG should work even if the shareholders hate each other, so that's quite difficult. But there is a legal component and there is a certain business component. If a foreign partner comes as just an equal partner, he brings some know-how, something else. But among the major players, if he won't agree, I think that frightens away many persons, and we have a potential for improvement here. Thank you. Further, I can tell you that though I think that practically it is impossible to win without the Russian partners, but we had such a precedent. That was a garbage processing plant facility where we have 3 foreign participants who were pre-qualified. 2 of them were from Singapore, Austria and Greece without Russian partners. They were just negotiations at the level. Probably some time will agree with you, but not now. 2 of them are competed quite strongly with each other up to some mini scandals. And I can tell you that the project is actively implemented and developed, and they say that it shows that you can find a Russian partner afterwards, after you win the competition. Of course, this is not typical now. More often, we need the consortium at the stage of preparation of the competition between the foreign and the Russian company. However, such things happen, and I would agree with you that this should be a possibility which shows to the participants that is not just an agreement between big guys from Russia. Thank you, Fyodor.
It is impossible to translate if speakers don't use microphones. What about guarantees? What about guarantees provided by the state? So if the answer is yes, then what are these guarantees? There is a saying in English. PPP is all about risk allocation, and PPP projects, the main actually thing about PPP is allocation of risks. And what is it in practice? For example, there are land plot risks. There are financial risks, there are design documentation risks, also there are lots and lots of risks. And the state and the private investor, they distribute these risks among themselves. In what way the state takes these risks? Through those guarantees, in a broad sense of this word, of course. It's not a guarantee like in the civil or administrative legislation. The state may extend the construction period, for example, or the concession period, or maybe pays a compensation, or maybe some payments will be reduced. And of course, if the concession agreement is terminated, then the state compensates to the investor and to the banks those obligations that exist at this point. So it is actually purchasing of this facility at a discounted rate. And speaking about those guarantees that are typical for the budget process, no, it is not provided, because it implies reserving all these funds in the budget, and this is quite awkward and it's not used. And this is done only if bonds are issued. You know probably that for many projects infrastructure bonds are issued, and for them to have a higher rating, the Russian Federation government took a decision to provide guarantees. But this is the only case I can think of. She's not using the microphone, sorry, I cannot translate anything. Ask her to use the microphone. Yesterday, Roman Golovanov was present at a business breakfast. He said that you can only appeal to the arbitration court to ask for compensation. So it is almost impossible to get the money spent on the project. Roman is a specialist on PPP project. He's not a lawyer actually, and it's not right to ask him legal questions. So what he meant, so if there's no understanding who is to blame, and then we'll have to go to the arbitration court. Yes. Thank you, Fodor. And now I'd like to give the floor to Trevor Wallace, specialist. Now we are going to hear about international experience, a UK experience, and it would be extremely interesting to learn about those projects that are being implemented in Great Britain on the basis of a PPP model. And I would like to ask the next speaker to share their experience. So in what way PPP has that potential to be efficient, and when it can be used, and maybe when we shouldn't use this fashionable mechanism, fashionable in Russia at least, and maybe we can think about some other models, some other types of projects for implementation. Thank you, Trevor.
Thank you, first of all, for inviting me to St. Petersburg. Isn't it warm here in comparison to London? Very warm, yes. Okay, next slide. If I can just perhaps start with a geography lesson for you and tell you where I'm from. So I'm from West London, the London borough of Hounslow. You can see there it's shaded pink. There are 33 local authorities in London. Hounslow is just one of them. And you can see the position there in West London, right immediately next to Heathrow Airport. And I've also marked on there the Olympic Park. The Olympics are very important to London in the current year. I don't know whether I can ask an open question, whether anybody's got an Olympic ticket. Anybody has an Olympic ticket? Just wait for the... Yes? No? Okay, but not yet. There are a few more. Okay, well, if you have got an Olympic ticket, probably about 80% of all the visitors to the Olympics will be coming in through Heathrow, and you'll almost certainly be flying through Hounslow airspace, and you'll almost certainly be passing through the borough. Next slide. Okay, just to describe the project that I'm working on at the moment, and this is my 7th PPP project in the UK. It's a highways project, and the statistics are up there in terms of the amount of carriageways and footways we're trying to remediate. It's trying to cover the entire boundaries of the road, so it will include everything, including the street lighting. It will include all the drainage and structures, and will also include the delivery of services associated with the highway, such as the street cleansing and the ongoing maintenance of the highway. Will also include the trees and verges, so that's all included. It's intended to be everything that was within the fence-to-fence boundaries of the highway. Next slide. Yes. Thank you. So it will be a 25-year project. All my figures are in British pounds, and in the first 5 years we're proposing to invest about 100 million British pounds. and overall it will be a project worth about £800 million. And that will include in that figure all the maintenance services, particularly the street cleansing. That's an expensive service. So those figures of 800 million include all of those costs as well. And how that will be financed, and this is fairly typical structure in the United Kingdom, is that that will be financed probably by about 40% of direct government grant, and that's intended to cover the costs of servicing the debt for the £100 million. So we'll be raising £100 million from the banks, and I'll be talking about that in a moment. And all of the debt will be met by government grant. Locally, in Hounslow, we will have to meet the costs of the services, and there will be a small amount of yield from interest on balances. This is because we don't have a regular profile in terms of the amount that we receive. In the early years, the amount that we receive in terms of grant tends to exceed the amount of payments that we're making, so we accrue balances that can earn interest and help to contribute towards the overall cost of the scheme. Next slide. Okay, just to show you what the situation is in Hounslow at the moment. If you are passing through the town, the picture on the left is what you will see at the present, that the roads are badly broken up and fractured. They're virtually impossible to clean, and certainly in terms of pride in our borough, it's very difficult to engender that sort of pride and ownership of the borough when your when your highways are in that sort of condition. So the picture on the right is intended to show what it will be like after £100 million worth of investment and how it will be maintained for the 20 years after that. So one of the products of that will be that we will have a lot less personal injury claims, and I'm aware, talking to a group of lawyers, that's not necessarily a good thing, but we do have a big trip culture, as we call it in the United Kingdom, that people are always claiming when they fall over those damaged and fractured slabs and carriageways. Next slide. Okay, so let's talk about the PPP, and as we call it in the UK, PFI, Private Finance Initiative, in a little bit more general terms, in the perception of the concept in the United Kingdom at the moment. We've so far delivered about 700 projects. So you would say in those terms it's been a terrific success. We've delivered projects in all sectors, including those I've shown on the slide, but in addition there are projects in the police sector, the fire sector, prisons, courts, virtually everything, hospitals. Virtually every public asset has been financed by PFI in recent years, and we've been doing this for about 20 years. I started in 1994 with a schools project, and now 20 years on, some of them are quite mature. Some of them have gone well beyond the investment phase or into that maintenance phase, and there may be some questions or some issues about that that we can pick up later. But I suppose in the United Kingdom we're having a slight wobble on this. We're beginning to wonder whether the PPP model is quite as good as we thought it was. Now, I've talked about it being successful, and I think it still is a successful concept. It still is a successful project. But there are questions about whether it is too costly, whether it is too inflexible, and whether there is sufficient transparency. I've described it there on the board as opaque, but I think the word you've been using this morning is transparency. There are questions about whether the level of profit that the private sector is deriving from these schemes is appropriate with the amount of risk that is being transferred. There has been some bad experience. In our local papers, you will pick up on a fairly frequent basis messages that PPP is expensive, particularly in the maintenance phase. You will hear people say, well, it costs so many pounds to change a light bulb or to do relatively minor works appears to be expensive. So we have this loss of confidence in the UK about PPP. I'm not sure it's entirely justified, and I'll talk about that in more detail in a moment. But we are looking to see if there is a case for a new model. Next slide. Okay, so what the UK government has done is it's launched a review through the Treasury to look at whether there is a new and better model of PPP. And it's asking these questions of the industry, whether there is a less expensive, more cost-effective model, whether we can be accessing wider financing sources, whether we can looking at the bond market, or whether we can be looking at accessing money from pension funds. We're looking at the balance of risk and reward, whether we are transferring the right amount of risk to the private sector and whether that's good value for money. And perhaps I'll come back to that in a moment. We're looking at whether projects are sufficiently flexible. I think this is one of the serious criticisms of projects, is that if you enter a contract for 25 years, whether in fact they are flexible enough to adapt to the evolution of services over time. Still have to retain private sector incentives. We can only play the PPP game if the private sector is prepared to play with us. We're asking ourselves whether we can achieve a more accelerated and cheaper procurement. Well, I'm not sure that that's a characteristic of PPP schemes. I think it's maybe more a characteristic of the type of schemes we're trying to procure. They are complex schemes, and we have European rules as well in terms of procurement, and I think many of the issues in terms of the cost and the length of time that the procurements take are associated with the procurement rules rather than with the PPP principles or concept. And we come back again to transparency. Are the deals we're entering into sufficiently transparent in terms of who's taking the risk and who's taking the reward? Personally, I don't think the model is broken, but I think it's right for the UK government to look at the model. And I think 20 years in, it's probably about the right time to ask ourselves that question. I can't really anticipate quite what the outcome of this may be, but I suspect the model may not be too radically different in the future. It may be rebadged and relaunched, but I think it may be a fairly similar model. Next slide. Next slide, please. Thank you. So let's talk about what the impact of the financial crisis has been as far as this project is concerned. I'm aiming to reach financial close in July of this year, so we're very close to the end. We have appointed Vinci as the preferred bidder, as the winner of this procurement. I think the earlier speaker referred to them as potentially a player in the Russian markets, so that they will be delivering the service. But what we are finding is that there are fewer banks who want to play this game at the moment, and certainly during my procurement of this project, we have seen that the French banks have withdrawn, the Australian banks have withdrawn, the Belgian banks have withdrawn, but thank goodness we've still got significant interest from the German banks and the Japanese banks. I've put myself a question down here about the Russian banks. I haven't engaged with the Russian banks, but I'd love to do so. Probably too late for this project, but you know, if the Russian banks have got money and they're prepared to take the appropriate amount of risk, I'm sure the UK market would love to do business with Russian banks. Okay, so there is a reduced appetite amongst the funders. UK interest rates are relatively low at the moment. I'm expecting to close this deal at a little over 3%, but the consequence of that is that banks are seeking higher margins. That my first deal I closed in 1994, banks were seeking margins of just over 100 basis points. In the intervening period, they've been asking for margins sometimes up to 350 basis points. I'm expecting to close this deal around 230, 250 basis points. So somewhere in the middle range, but there's been quite a fluctuation in the amount that the banks want in terms of their margins over and above UK interest rates. They're also offering a shorter hold period. This is the term in which the funders will offer their terms. In the past, they would offer terms for 6 months. Now it's difficult to get more than 3 or 4 months. I think I'm quite fortunate. I've recently refreshed the funding terms with the 3 banks that we have, and their holding terms for 4 months. That's comparatively good in the UK market at the moment. That's about the best you can do. Also, although I'm only looking for £100 million, there will be 3 banks involved. The banks are taking less risk in terms of the amount of money that they're proposing or prepared to put into projects. This is likely to be a 40-40-20 deal between the 3 banks. A few years ago, a £100 million scheme, a single bank would probably have been prepared to take that risk. Now they're cutting it 3 ways to distribute the risk between the 3 banks. And of course, they're all seeking to do a lot more due diligence to make sure that their funds are not put at risk. Next slide, please. Thank you. Okay, so what advice can I offer you on the basis of my experience entering into PPP schemes? I do think you need to have a very good vision of what you want the outcomes to be. And I'm guilty of all of these things on this board. I've sometimes started projects without having a very clear vision of what I wanted the outcome to be, or my client wasn't clear what they wanted the outcome to be, and we've tried to develop the specification as we go along. I don't think that's a good idea. I think you ought to have a good idea of what you're trying to achieve at the outset in terms of your project scope. They are output-based projects, as one of the earlier speakers referred to. And you also, I think, if you can use standard documentation, we've got standard documentation in the UK, that's good. It saves reinventing the wheel in every set of negotiations that we've got. And you can, I think, reduce the timetable if you're prepared to use standard documentation, the product in the UK of 700 odd schemes. Make sure you have good data. Again, the previous speaker referred to this, I think, in a sense, in talking about if you're going to involve land, make sure you've got good title to the land. If you're going to do a highways project like I am, make sure you've got good condition data to start with. Make sure you know what your asset is. Make sure your inventory is up to date. And if it isn't up to date, spend money up front early on so that you can give your bidders and, by derivation, your funders good information about your asset and what you're trying to achieve. I then described good concession standards, and again, this is about performance targets and how this links to the payment mechanism. We've talked about demand risk earlier. In the UK, we don't normally try and transfer too much demand risk. We don't regard that as a good commercial or financial proposition. Demand risk is often in the control of the public sector in one way, particularly if you're talking about highways, or I tried to build a tunnel once before, and one of the reasons that faltered and the government ultimately cancelled the scheme was I think we had the wrong concession structure, because we were trying to transfer demand risk, whereas all the drivers for demand risk were held by the public sector. We were the ones who determined parking policy and access to city centres, and we were the ones that ultimately would determine how many people would actually travel on the tram. They were the passenger numbers for the tram were really derivative of the local government and national government policy for transport, and it was very, very difficult to transfer the demand risk. We could have transferred design risk, we could have transferred construction risk, but it was virtually impossible to transfer demand risk, and ultimately that scheme failed for that reason. The risk pricing just made the cost of the scheme out of this world and beyond what the government and the local economy could afford. Be realistic about your timetable if you can, and my advice would be, having set a realistic timetable, try and stick to it. This will give your bidders and your funders confidence that you know what you're doing. I think there's plenty of precedent examples in the UK where we've started on projects and they've taken a great deal longer than we thought they were going to take. That doesn't inspire confidence, either in bidders in terms of their costs or their attitude, or in terms of the funders in terms of their costs and attitude. So try and get it right first time if you can. Easily said, not so easily done. And linked to that, I suppose, is don't start until you're ready. If you need more data, if you need to refine your output specification, I would commend to you that you do that before you engage in the bidding process, before you start the competitive process, and make sure that you're ready when you start the procurement process. It will save everybody time and money. Make sure your project is well resourced. That can be an issue for the public sector. Certainly in the UK, projects have failed because they've not been sufficiently well resourced, and you're not able then to respond to the timetable that you've set. And I suppose finally is that I think as a visitor from the UK, I think the UK's credit rating is still good, and I think we're still open for business. We're having a little bit of an exercise about looking at the PPP model, but I think we still have business to do with the European banks and potentially in the future with Russian banks. Thank you.
Спасибо большое Тревору. Вот я не знаю, как, уважаемые господа, вы.
Thank you, Trevor, very much. In the presentation of Trevor, I found a lot of associations with those presentations and experience of PPP projects that are available in Russia. I would like to share these impressions with you now and ask a couple of questions to Trevor. I think it is quite surprising for us. We always thought that the projects, the UK projects, were most flexibly built, always complying with the specific features of the project. From the viewpoint of the legal scheme and from the viewpoint of the payment mechanism, they can be suited with maximum flexibility to the specificity of the project, unlike the Russian project that was stringently assigned by the federal law or some. And sometimes they will be more flexible in the regional legislation. Nevertheless, we have rather rigid structures. As to what was mentioned by Trevor, I was a bit surprised that it appears that in the UK is one of the issues of improvement of BBP that is currently being raised by the authorities of the UK and the Treasury is that it is necessary to improve the flexibility and to get adapted, to adapt to the changing situations in the financial markets. And these questions are currently being raised as urgent in the United Kingdom. So you can see how much we have to learn to improve our own practice of implementation of PPP projects that concerns not only those who build these transactions, but that also concerns the laws, so that we should provide the maximum flexibility of legislation so that it would help further negotiations. Trevor said that there are more than 700 projects that have been already implemented in the UK. My first question to Trevor is that great number of projects doesn't make it possible now to draw the conclusion where the PPP in most cases might fail and where probably we shouldn't build the schemes of project implementation under BPP, but we can use simple procurement or other mechanisms. Or in your opinion, there is no common answer and everything depends on the possibilities and features of a specific project.
Okay, thank you, Alexei. Yes, I didn't intend to suggest that 700 projects had failed. I think most of them have succeeded. I think the trouble is there are few that are perceived to have failed. Now, what we've learned over 20 years is we've learned a lesson. I think some of the projects that we signed in 1994 were inflexible, and we've learned over 20 years that we now have to build flexibility into the projects, and we've now got quite a detailed change protocol, as we describe it, which is fairly standard across PPP projects so that we do have that flexibility built into new projects. Unfortunately, it's always the few that drag the majority down, and there are a few projects, and these are the ones that attract public attention, where the inflexibility is regarded as a problem and a barrier. But I think of those 700 projects, probably 95% have been a success. We've built a great many assets as a result of that, and generally speaking, it is a success in the UK, but we do have from time to time this process of revisiting our models and asking ourselves, is it still the best approach?
Да. Да, конечно.
Thanks. I'd agree with Trevor that there have been some remarkable failures, Metronet being one of them.
Yeah.
But my experience is generally in the UK that where they have failed, it is because of poor preparation by the public sector procuring authority. And I've seen this very many times. I did a schools project some years ago, Brighton Schools, and it was closed, completed. And 6 months later, one of the schools that was in the project, the local authority decided they were going to close it because there were insufficient pupils. Now, they must have known that there were not enough pupils for that school. So why did they include it in the project? And it's catastrophic mistakes like that that cause problems when you come to vary a contract. I think that cost them about £7 million to remove that school from the project. So, as Trevor said, you must get the groundwork right. You must get your specifications correct, and you must know what you want before you even consider going to the market on these things. Thank you.
Да, спасибо, Энтони.
Thank you, Anthony. Of course, this is similar to the advice given by Fodor, who said that if you want to implement PPP projects, they have to be prepared quite carefully, and you have to understand what you want. Otherwise, the procurement that will be, otherwise you should have a state procurement. And the last thing that I would like to mention, which is quite close to me, Trevor said that in his opinion, the delegation of the demand risk under PPP project from the state to the public sector is a bad idea. And in many PPP projects where such an attempt is made, they are not stable, and it is clear why. And due to the fact that both federal and regional authorities, particularly in respect of transport infrastructure, has a great number of mechanisms when even not without any wish they might disturb the balance of demand and traffic that was previously involved. From Fodor's presentation, these two federal projects, M1 and M2, where the demand risk was totally delegated to the private sector, where the state does not guarantee in any way any changes in traffic, despite the fact that the traffic that is going along these two highways is quite high. But I think that this is the first and the last two projects in the highway sphere, in the transport sphere, when the traffic risk is assumed by the private partner. Probably that was a time, and that was these were the only areas where a private partner was ready to risk how many cars would use, how many vehicles would use the road which he built, irrespective of what happens in the nearby roads from the viewpoint, on the nearby sites from the viewpoint of new construction, development, or other actions of public authorities. I agree with Trevor, particularly in transport construction. the passenger flow or the vehicles or passengers who take public transport, their number depends not only on the quality of the services for which the private sector is responsible, but it also depends on many other circumstances related with public sector. I mean, quality or high quality or low quality alternative highways, and the tariff rate or the cost of the ticket in the region, and the welfare of the citizens. So there are a great number of issues that are related with traffic, and these issues are assumed by the state. My forecast is like that in near future, the project in the sphere of transport where the traffic and demand risk will be assumed by the private sector will not exist in future. Anyone else who might have some remark, a question?
Yes, please. My name is Ögmundur Jónasson, and I come from Iceland. I'm the Minister of Interior in Iceland, and my background is in the labor unions. I have had quite a great deal of cooperation with British unions, Unisons amongst others, who is very critical of the PFI programs in Great Britain, and I followed this with great interest. I'm happy how balanced your introduction was, Mr. Trevor Wallen. Now, it seems to me that the pressure for PFIs has been twofold. Firstly, from politicians who have wanted to hide commitments they make on behalf of future taxpayers. At the same time they are opening schools and hospitals and new tunnels, etc. Their commitments has been to provide the users into the future, but they can hide their financial commitments. On the other hand, the pressure for PFIs has come from investors who want to find safe channels for their money into the future. Of course, you know that we have to run a hospital and we have to run a school in the future, and this is risk-free in that sense. Now, we have been told that the benefits for society is competition. Now, what I want to ask about is the real value of competition here. You see, I once saw statistics provided by Unison showing that the PFI contracts in hospitals, for instance, in Great Britain, had to an amazing extent been renegotiated at a later stage, so that competition at the early stage told us nothing about the real outcome in the future. But they also showed how there had been created an aftermarket with PFI programs. So, and you know, I'm wondering how beneficial this is for society and for the taxpayer when you know, when we look at the question in its entirety. We are now in the process of building a new prisons in Iceland, and there has been very great pressure on us to enter PFI contracts. But we find out that this is much, much more expensive for the taxpayer in the long run, because capital will cost more. And this, as Trevor Wallen said, this is at the risk of inflexibility. In times when we need flexibility in public services, why on earth should we commit ourselves into the future, 20, 30 years into the future, in such contracts? I think it is a mechanism of the past, and I think people should be very careful about using it. It's a great temptation for states that have financial difficulties in attracting capital in these ways. But for the taxpayer of the future, it's disastrous, to my belief. This is what I think I've seen from the experience in Great Britain, in New Zealand, where they went overboard, and elsewhere. So I think those who are advocating these processes have a lot to do in proving for us, the taxpayers, that they have a good package. Thank you.
Thank you. You're going to have a word afterwards? Point number one is that this was a report by Unison. It is well known in the UK that the unions do not like PFIs. The reason they don't like PFIs is because it removes public sector workers into the private sector, and they don't feel that the private sector terms and conditions are likely to be as good, notwithstanding the fact that there is legislation requiring the same terms and conditions to be kept. As regards the alteration and variation of contracts, yes, that does happen, but it should not happen to the detriment of the public sector. If it has done, then it is clear to me once again that the public sector negotiators are not up to their job and they should be replaced. It is a common theme throughout the world with all PPPs that the public sector tends to be outgunned by the private sector. The private sector will employ very good lawyers, very good accountants, and very good technical consultants in order to advise them when procuring these sorts of contracts. Very often the public sector believes it can do that expertise itself. And I always equate it to a 5-year-old child with a water pistol going up against the fastest gunslinger in the West. He will not win. And I've seen it very many times. So it's important that there is equivalent skills both in the public and the private sector when dealing with these, as it does in every other project. As regards the increase in expense, the National Audit Office had a look at this very point in the UK, and it turned out that overall, taking into account life cycle costs, the cost of PFI were generally around 14% less than traditional procurement. And my final point is traditional procurement, again, is notoriously badly done by the public sector. And my favourite example of that is the Scottish Parliament building, where the public sector estimated that the cost would be £40 million. By the time it had completed, it was over £500 million. That is not good procurement practice, and that is one of the things that PFI does to an extent address. It gives a sense of discipline in the public sector when procuring. They have to start it right and they have to continue getting it right. So whilst I appreciate what you say, I don't always agree with you. Thank you.
Thank you. If I may, yes. I think you made a number of points there, and I think one of the reasons that some of these early projects have to be renegotiated, and I think this is a key point, is because they were over-specified in the first place. And I think this is my point about getting it right first time. Be clear about what your ambition is and what you want your outcomes to be. And I think many of the projects that we started initially, and again I'm probably guilty on this, is that we over-specified, that we let our imagination and our vision for the service run away with us. And we over-specified the hospital or the school, and now I think we've got to be much more realistic, much more pragmatic about levels of service and about the asset that we're trying to procure. We have achieved, I think, value for money. I think that's demonstrable, and I think also, and you have got concerns about staff transferring, and I appreciate that, but I've seen on many of the procurements I've done that the staff we've transferred have done very well in the private sector. So I don't think this model is broken, and the modern, the later procurements, I think, have been very successful.
I just wanted to complement what Tony and Trevor said, and by way of advocating in favor of PFI schemes. I'd like to refer to the similar example, to the same actually example that Tony made. The whole point is why you initiate PFI or PPP as the preferred arrangement structure, which is threefold: price certainty, timely delivery, and reduced construction cost. Tony has touched upon the third one largely. I just wanted to refer to the National Audit Office statistics made first in 2003 and then in 2008, to which Tony referred to already. And they actually, I happen to have this with me. In terms of price certainty, they came to the conclusion that percentage of project delivered without costs overrun reaches 70 to 80% in PPP procured projects versus 20-30% for traditionally procured projects. That's one thing. Another thing is the delivery on time or not on time. The percentage of projects delivered on time by private sector partner reaches 70% for PPP contract versus only 30% for traditional procured projects. This is a well-known statistics, and this is something to be borne in mind.
Not by unison.
Well, that's National Audit Office.
Well, I would like to add that, you see, I think one of the problems of our time, as was the problem of the 20th century, when you had states like the one we are in at the moment, which were over-ideological and used to reject all empirical data, be pragmatic. The danger has been the same in the West in recent years, when it has not been communism but neoliberalism, which has been the new ideology of the day. So I think it's very important that we are very, very balanced and honest when we look at the data. It is not correct, sir, that it's only the findings of unison which has been critical of PFI programs in Great Britain. I have also seen reports made by the BBC, for instance, in very extensive programs with interviews and reference to reports from Labour and Conservative politicians, very, very critical of PFIs, referring to experience, as indeed Mr. Trevor Wallen referred to, that there was now time to reconsider the experience of PFI. And I think it is unfair to say that on the one hand you have the brilliant lawyers of the private sector against the stupid ones. Well, you did that, you know, a little child with a water pistol against the real professionals. And you see, and the labor unions in Britain and elsewhere in the world, which I know quite well too, they are not only concerned with the conditions of their workers, but they are also referring to the interests of taxpayers. And mentioning the building of the Scottish Parliament, I would refer to the British Channel. How much did that cost in the end? And what were the original plans? That was PFI, as I understand it. So let us not be too dogmatic, and let us look at experience and be very, very critical. I am also talking from experience of PFIs in Iceland, and they are very, very bad.
Большое, коллеги, у нас уже такая дискуссия завязалась, которая, собственно говоря, и была немножко спровоцирована в начале.
Yeah, so this discussion has been provoked in the beginning. I would like to add my own vision because I'm a moderator of this session. In fact, two major questions that we have been discussing so far. The question how whether PFI model or PPP model, as we call it here, whether this model has serious drawbacks, and maybe we should reconsider it and propose a new model. It's very useful for us to be part of this discussion because we are at the initial stage of this process, but I believe it is impossible simply to compare the money. Yeah, of course, in terms of construction, yeah, if we see public procurement cost and PPP cost, yeah, it will be more expensive. PPP will be more expensive. And this is what we heard from the speaker from Iceland. But can we only compare the prices? Because we need to compare the whole life cycle of the project, and when we start counting how many times after completion of the construction of a school or a road to finance repair works or maintenance work of this road or a school, because the contractors don't have any motivation, or if we also can consider some organizations who get money from the state budget, they are not incentivized to save funds. And if we compare it with maintenance or operation by a private investor, because everything is specified at the beginning of the 20-year period. Even the current statistics shows that the cost of the life cycle operation cycle is much lower in comparison with public procurement, because there's motivation, there's a stimulus there. And the example, a kindergarten and school projects. So the construction of 3 schools is more expensive through PPP. Yes, it is more expensive, but maintenance and operation is less expensive because there are special heat distribution units, there are special dimmers and energy efficient equipment for the swimming pool, and as a result the cost of maintenance is 40% less than in a regular school, and within 10 years, yeah, it gives a result that reduces the overall cost. Or in terms of the time frame, let's compare all those cases of non-compliance. I mean, public procurement. It is famous examples of American bridges or a big football arena. The time frame is violated all the time, and the cost gets bigger, bigger, and bigger. Why? Because it is public procurement, and this scheme sort of allows for that, and they requested for more money, and they justified it, and this is the easiest thing that can be done within the public procurement. And in a PPP model, for example, our airport in St. Petersburg, they follow the schedule to the day. So, and by December 2013, yeah, the new terminal will be in operation. Of course, we have very, very few examples, and that so far, I believe in St. Petersburg at least, there's no example when a PPP project has a problem in terms of an increased cost of construction or non-compliance with some significant terms and conditions which are part of concession agreements. Now, Vlad Zabrodin is from legal company that supported the government a lot in the first large PPP project in Russia. And again, it was financially closed. There was a financial closure. And it was 1,200,000,000 rubles financing. So, Vlad, I have a question to you. Are there problems with PPP projects in Russia? What about prospects of this model, and what do we need to do in order to consider the experience so that we learn our lesson? Thank you for your appreciation of our work in this project. I have a couple of things to mention about the Pulkovo project. Yeah, that was almost one of the first projects that was successfully financially closed, and difficulties that we faced, they were largely related to legal ambiguity. And the topic for my presentation today is linked to changes in concession agreements that and revisions of the law. Yeah, it takes place regularly, and we even underestimate the situation, because if we speak only about concession agreements, yeah, there are regular revisions, but at the same time, because the sphere of PPP regulation is wider than just a concession agreement. And I heard today that PPP is more of a political nature, not of a legal nature. Legal is very specific. It relates to a specific form of this PPP. And concession is just one type of a PPP. And the law that was mentioned by Fedor Teselkin and what Alexei mentions, the local law of St. Petersburg, this has become a model law for many regions in Russia, because this regional law, it is revised, it is being modified, because in the course of implementation of specific projects, it is necessary to see that we start understanding mechanisms that regulate involvement of participants of this project. And Pulkovo Airport is a good example, because within this framework, within this systemic approach to the project, and actually this determined its success, the city realizes the tasks. And this is for both for the city and for partners within this project, and also requirements of the banks. And the city was ready to revise the local law, and that provided great assistance to the project. I believe changes in legislation, this is an indispensable part of implementation of any PPP currently, and that law 115, it is a good example how fast everything changes. The law doesn't change so fast itself, but this is inevitable. So there's a constant demand for changes, but there should be a balanced approach, because if we react to every single change, then we might make a lot of mistakes, because we won't be able to see the long-term consequences. One of interesting things in Trevor's presentation, and in the end I would like to ask him a question about how this flexibility that is reached in the practice of is reached in the UK How is it balanced by approaches and conservatism of legislation itself? What is the legal basis of this? What is the regulatory basis for all these processes? And if we speak about Russian experience, for example, we are absolutely clear. If we start changing conditions of concession agreements, then we have a very clear risk that there will be disputes and claims, and there will be claims from participants of tenders who will see that concession agreements are changing and the parties couldn't prepare, or the bidders couldn't prepare the right proposal, because any changes of agreements influence the possibility to implement all the conditions. So how is it possible to say that those initial conditions were absolutely fair? So whether the investors or those bidders, whether they should think or believe that the terms can change, and during the preparation of their bids and later during negotiation of the agreement, what can be done? Of course, these are endless questions, and if we in the process of in the course of this discussion, I actually wanted to deviate from my presentation and have a just a discussion, a dialogue. Still, I'll show you some slides in my presentation. So first slide, please. So changes in legislation. We'll see that there is a certain current understanding of concessions, and at the same time there's a changing reality that makes public authorities, and usually there are not just two parties of this process but more, it makes them understand that certain conditions of cooperation between parties need to be changed, and those revisions that were introduced in April of 2012, and that was in the law on concessions, I believe they demonstrate very well those tendencies that the beauty of St. Petersburg is that being in the first roles of implementation of PPP project. And here parties always find some ways to agree on something and to...
And one of the issues that I would like to mention, why was it necessary to have a law on PPP? Primarily because the law on concessions was absolutely rigidly tuned to a specific system of project implementation. It was so inflexible that the parties, realizing that possibly the federal money will not be used. It would be impossible to use federal money in the project. We understand that the project is necessary and economically viable, so they used local legislation to evade those strict barriers imposed by the concession laws and concessions. And the example of Pulkovo is quite interesting. Just imagine a huge airport for a 5 million city, a huge flow of passengers. The airport is a very complex organism related with the fact that there is aviation safety, international agreements, and military component of all of such objects exist. Many questions which arise, tariff system, they are related with federal legislation, but the city found was brave or impudent, so to say, enough to avoid the federal law and to pass on to local regulation, realizing that this local regulation might will make it possible to efficiently attain the result. Speaking about the concession agreements, please pass on to the next slide. If I analyze the situation from the viewpoint of changing legislation, what we're going to see, the legislator is always conservative in his approach. First, he's conservative because he doesn't have enough practical experience. He's afraid of making certain errors, which then will come back to him from the viewpoint of necessity of amending new amendments to legal acts that were adopted not long ago. The legislator understands that the current sphere, if we recall the theme of our discussion, PPP and crisis, we realize that the possibilities offered by the public-private partnership in the period of crisis form a win-win situation. The state not always has money to very significant, important social infrastructural projects that require investments. What can the state do? It can state that it is not effective enough, it is not ready to do everything and have the resource to realize the project. But the parties can do it quickly and efficiently. Let us see how it works. And the state in this situation chooses the spheres that are interesting, and the spheres are quite diverse. I think that for all people, the most contradictory sphere are prisons, and Russia so far is a bit conservative in this approach, but that will be the next stage to which we're going to come. Now we can clearly see that the trend of passage of major infrastructural projects related with highways, airports, very serious investments into for instance, waste processing, water treatment. Gradually it passes on to the next stage, schools, kindergartens, certain cultural centers, sports structures. That is good reason and a reasonable approach of the state to understand that I have certain restriction, will or nil. I have to realize my restrictions and to make my restrictions my strong point, and that possibility offered the interface of public and private business, though Alexei said that it calls for associations related to corruption. It might seem paradoxical, but I think it is far away from corruption, because corruption primarily emerges related to the possibility of the state using public money to reach some personal interest of specific individuals. The interest and the difference of PPP or private partners is that the money is not the public money, and the possibility of misusing the fund or granting them to a wrong counterparty is decreased significantly, because the level of requirements imposed by the counterparty is more extensive. The level of their specialization and skills is more serious than in common agreements on state procurement, and the quality of the partner and the quality of the party participating in the projects at the level of private business, as a rule, is much more serious. Moreover, there are several parties involved, and in this situation the possibility of misusing is reduced as compared to the specific state procurement. Next slide, please. I would like to briefly dwell the three main changes which occurred in concession agreements. I think that we can slowly browse this slide and the next one, and three main issues that seem of utmost interest for me. Because what do they reflect? They reflect the wish of the Russian Federation to follow the global experience. The possibility of using global experience in concession agreements was restricted by very stringent restrictions that existed between the parties in the possibility of concluding an agreement. There was a standard agreement, and there was no possibility of negotiations in that agreement. Besides, as further mentioned, the possibilities of concluding a direct agreement with the bank was restricted by one bank, and there was an impossibility of negotiations. What happened in April 2012? I can say that we are fully satisfied by the changes, but the trend is correct and important. The first thing that was done, a decision was taken that we can reject a standard form of agreement. This is quite critical because the changes which were adopted were mainly are currently acting in respect of the questions concerning highway construction that was related with the public company Rosavtodor. I think that the next step will be applying these changes to new spheres of PPP. As to Rosavtodor, we know two problems in our country, and roads are one of the most important problems because the ability of the Russian people to analyzing the situation and to cognition is much higher than the quality of our roads at present. So I think that problem of not very clever people ranks second, and the problem of roads ranks first. If we try to solve the problem of roads, we understand that we have several structures, federal structures, which are responsible for these roads, and these federal bodies at present are not successful in their activities, and their possibility of succeeding is related with the possibility of being more flexible in their approach to attaining their purposes, and that possibility is related with legislative restrictions which existed and which are gradually removed. The first of these restrictions is the impossibility to use only one form of agreement provided for by the law on concession. Now we have got such form. We can use the global experience, the global practice, and the terms determined by the parties in the agreement on road construction can be fully used in the Russian Federation. Secondly, it is also quite important, and it has a long-term value. This is a possibility of negotiations based on the results of competition. Until recently, we said that there was a competition, there was no negotiation, and the only possibility was to conclude an agreement in a certain form. Now the parties have a possibility to pass on to the level of negotiations after the competition to agree on the conditions that were not essential for the competition, that were not part of the offer that was made by the investor submitting an application for project implementation. It is quite important because it adds flexibility. If the investor said that he was ready to act within such frames, these conditions have to be are a part of the competitive documents or tender offer, and they shouldn't change. But the conditions that were not determined, that can be important and significant, can seriously change the position of potential investors so that they would be involved in the process, understanding that they have a certain flexibility. And the last item, which is this is a direct agreement or an equivalent of direct agreement existing in the British law. The agreement with creditors previously further was right. There was a possibility of concluding an agreement only with one party. Now the number of the parties is not limited, and what, as was mentioned by Trell previously, 100 million financing could be assumed by one bank. Now such situation doesn't exist, and the banks are much more conservative in their approach. They try to share the risks, imposing certain risks on the city, but the possibility of attracting certain banks and their participation in the process doesn't make the negotiations easier, but it makes it possible to get more realistic options of financing the projects, and this is a very serious step that can be mentioned. And now let us pass on to two other slides. Move on, please. There is a possibility of changing direct agreements with the banks. In the next slide, you can see another serious change which occurred in the legislation. Previously, we said that the possibility of delegating the rights under the concession agreement would be impossible if, for instance, the contractor which conducts the construction work cannot be changed. Now, it is possible to change a poorly operating contractor not by the city or by the state, but by the banks, because the banks are actively involved in the process and they really, at an earlier stage than the city, are capable of determining whether there is a risk zone that the grantor would not fulfill his obligations, concessioner would not fulfill his obligations, and the contract he has to be changed, and the possibility of changing him at the stage when the project has not yet started, the stage when it will be impossible to realize it. It is a very important possibility for the success of the project. This is changing seriously, and we count on the fact that in addition to using regional legislation in respect of PPP, concession agreements would apply to more serious and broader spheres. The interest among the Russian and foreign investors is quite obvious. Alexei clearly outlined it in the option related to waste recycling. A similar interest, probably an interest in broader spheres, is related to water treatment. The parties are ready to get involved into the processes because they represent economic, social, and long-term interests for the companies who can undertake these projects. And on our table we have several projects with water treatment, not only for St. Petersburg, though St. Petersburg was a flagship in that field. They are related with numerous different regions of Russia where the parties are interested in investments of new technologies and new possibilities in exchange for long-term understanding, financial stable structure that would make it possible for them to work for a long period on these projects and making serious investments at the initial stage. Then they will later get the advantages and will effectively operate and control the project. What do we expect from the changes in legislation and from our legislation and those laws that will be applied in future? Legislation in the sphere of PPP changes not only the laws that are related to PPP, it also changes in other spheres. For instance, amendments to the civil code will provide an incentive for changes in the sphere of PPP, not always directly but indirectly. We think that the number of projects will be increasing. Pulkovo project, being a flagship, provided a very good level and showed the possibilities. On the other hand, the investor fulfills his obligations in accordance with the schedule. We can also look at the business aspect of the situation. The number of passenger traffic that was initially involved in the project increased without proportion to the expectation of the investor. At first it was 6.5 million passengers, now the level is 10 million passengers. For 2012, according to the basic model, it was 9, and now it is clear that it will be 11. So it is supported by legislation, by that business model. It develops, not always depending on the city or specific individuals. It is dependent on the economic situation in the country, in prices for oil. It depends on the political situation of the country, but we can clearly see that the project is quite successful, and how it will be realized, which provide additional possibilities for external investors, and they will be able to more effectively and urgently respond to the possibilities available in this country. Approaching to the international standards, I can't see the slides, that's why I'm turning back. As to the changes in the standards and approaching of the international standards, first we can say that the international standards are changing constantly, and the way passed by our country is much quicker than those than for the countries who participated in the process for 20 years. Alexei was quite right when he said that 20 years experience of PPP project, and probably even more, gives a certain retrospective and understanding of the problems and how they emerge, what is the basis for avoiding the problems. We don't have such experience. Therefore, using the international experience and the developments and learning from the negative consequences which we can see in respect of the UK, Iceland, we can understand how this can be changed now, and so that we won't have the problems which the countries that have long realized these projects are facing. If we analyze the situation on a real basis, I think that it is optimistic. Probably I'm over-optimistic. When we started the project on Pulkova, that was an interesting project for us. We were also quite optimistic. But moving with that project, and it took us 2 years to prepare the documents, to work on the documents, and to change the documents, to change the initial concept and the legislation. Probably we learned two important things. First, the problem which might arise will be quite numerous, and we have to be prepared for that. The process is not easy, and the second experience probably was quite positive for us due to the fact that we had a positive attitude to the project, and there was a support from the city. There was a political will in the realization of the project. We realized that whatever the question that might arise in the process of realization and drawing up tender documents, drawing up the contract, interaction with banks, interaction with financial advisor, technical advisor, all these problems could be solved. They might cause difficulties at some period of time, but we know that there might be obstacles on any road, and if we have chosen the correct trend, and if the movement is positive, if that system has a long-term positive prospect, these barriers will be overcome. As to our legislation, I'm sure that we shouldn't take into account what is available. Now we have to understand what is available, and we have to assess what is available. The legislation will change, it is quite obvious. As for the prospects of the projects in Russia, I think that the country is so big, and the state has a great number of social infrastructural tasks, and these questions will cause a greater interest of the state, and will have more and more experience, so it will be easy to solve these problems at the next stages. And I'm quite sure that sometime probably our experience which we get here will be in demand in the West, as the experience of people who have passed on from the zero condition to the condition of the developed system of solving such problems. In fact, probably I'm too optimistic in my approach, but I base this optimism on the currently available experience. Being optimistic, I try to be weighted, and I realize that when realizing these tasks, we have to clearly follow the examples and the experience which other countries and other projects accumulated, and realizing the risk each time, we have to retune ourselves to use the flexibility that has already been mentioned, and due to that the project will be implemented better and better. Thank you. Thank you. I will ask your question. You gave so a lot of information, and your speech was quite quick. So I'm afraid a bit for the translators, but I'm sure that you will support the statement of Fedor that what has to be done so that PPP will move further. He pronounced two ideas: professionalism of the state officials and those who prepare the project, and we agreed with it. And secondly, greater transparency for the foreign business. It is difficult to argue with it. And what else, in your opinion, as an experienced person who studies PPP not only in St. Petersburg but also in Russia, what else in other region would be the key factor that has to be taken into account by anyone that can be brought on the basis of all the contacts for all the persons who take decisions? What should be done so that PPP would develop in Russia? I think that most of the questions have been covered in this situation. The first problem which you come across at any level is misunderstanding what it means. In other words, the word is popular, the idea is beautiful, and everyone is quite joyful, but without understanding that this is a long-term and tiresome preparatory work.
And further, Tsolkin was absolutely right. How many times we met and discussed some future projects, but the initial stage was, very far from its ideal shape. So it is absolutely impossible to speak about a project, whether we have 3 documents or 10 documents. It's not the number of documents, but the matter is that looking for specific players in a project, banks, for example, all parties need to understand very well what is required. So I believe the very main first task is educational. We need to popularize, not at the level of popularity like songs, popular songs. No, it should be well structured, and the approach should be absolutely clear. So probably some model documents, standard documents need to be developed, and EBRD can be very helpful in this respect, because then this will form the basis for local governments, which will allow them not simply dreaming about projects, but implementing them. And one more thing that hasn't been covered today, but I believe it is very important: Russia today is viewed as a very risky market, and there are certain grounds for that. But as a consequence of that, we see that activity of banks is limited, and we see that sometimes when a bidder is a consortium of foreign countries, then there's a concern: how could they win without a Russian investor? Yeah, and the whole project, if it is not well thought over, but simply it's like just glued together to different bits and pieces, so then there are lots of concerns on the part of the banks. Yeah, and this concern, is true about both international and local banks. So I believe, and availability of inexpensive financing, real money that can be contributed to the project, this is a very good stimulus for these projects. And now, whatever we may speak, this money is not available. So it is extremely difficult to obtain this financing, and involvement of very, very large players with well-established reputation, and also some security provided by the state. This allows to implement projects. So I believe this stops the whole process. Thank you, Vlad. Yeah, you raised a very important question. What is of primary importance, the money or a high-quality project? So, because Alexei is whispering, so we do have money, but where can we invest? Yeah, because those guys, they just have, 3 sheets describing some idea. It's not a package of projects. It looks like we are not going to have a break. Yes, we have only 5 speakers. The sixth of us was not allowed into the building. We have one more speaker. It is Anthony Smith, who has already spoken a lot, but I still believe that his presentation will be very interesting. So let's listen to Anthony, and then we'll have about half an hour for questions and answers. Anthony, the floor is yours.
Alexei's gone. Must be something I said. I'm going to speak on the actual topic that has been advertised today, development potential in the economic crisis. So we're really concentrating on this speech on the finances. How do we get it? So next slide, please. Next slide. So I look at the sources of funds, what needs to be done by the private sector, by the procuring authorities, by the state, and quickly what other countries are doing, and I'll concentrate on the UK and France. Next slide. Next slide, thank you. Banks are obviously still a primary source, but the retiming of credit to better quality projects with more conservative project structures. What that means is that if you are trying to get a project procured, you are in a very, very competitive market. So you've got to make sure that your project is more attractive than projects in other parts of Russia or projects in other parts of the world if you're looking at international investors. There is a finite amount of funds and it will go to the most attractive market. And it's always very important to keep that in mind. There's obviously the capital markets, but the cost of borrowing of the private capital, as we heard earlier, is higher than public sector borrowing, 1.5% to 2%, possibly even more. So it is more expensive. There's also the multilateral lenders, European Investment Bank, Asia Development Bank, World Bank, International Finance Corporation, EBRD. There's a lot of them. They are very useful as funders in these particular projects. And then, of course, there's the state development banks and the states themselves. Next slide. So what do we need to do? There is a problem. Capital has dried up. I did this speech beginning of this week before the news about the Eurozone came out. So, I mean, it may be that banks were the most likely source of funds, but hopefully next week there will still be some banks. You just never know. So we need to change the way we've previously done things. So what ought we to do? And there's a number of potential things we can do. One is to adjust the procurement process. We've heard from a number of speakers today just how difficult it is to procure PPP projects under the existing legal regime. You need to allow for final adjustments to final offers based on funder requirements and allow bidders access to unsuccessful funders to increase the pool of funders. Many procuring authorities say that you have to have exclusive funders. That's not clever when there are very few of them. So you're excluding any funders who were tied to unsuccessful bidders. You're far better off allowing those to transfer over to the successful one. Reduce the contract duration. banks will not lend for the tenor that they had before the credit crunch. So you're left with refinancing problems. One way of dealing with that is to reduce the contract duration. You may also find that that is good for the public sector because you remove some of the requirements for variations over the length of the contract because there are less changes in less period of time. You can improve the risk and reward balance. More balanced terms, placing the risk on the party best able to deal with it will provide better value for money and a greater appetite to provide funding. This is a common problem in projects where the public sector think, there's risk transfer in PPP, so they transfer all the risk over to the private sector. And there was one only last year in Abu Dhabi, the Gwayhat Mafraq Highway, which collapsed, and one of the reasons that it collapsed was because they required trees right the way across the highway, which on either side of the highway, right the way through the desert. Now, that is a ridiculous requirement because that would require the construction of a whole desalination plant just to provide water for the trees. It really doesn't make sense. Now, the risk of that is very high, so the private sector will build the cost of that risk in. Every time you transfer risk to the private sector, it will cost you. And if they can't manage that risk properly, they will look at it as if it's going to happen. Even though there's a very small likelihood, they will still mark up the cost of the project to the public sector. So it's very, very important to ensure that there is an evenly balanced set of risks and that the private sector is satisfied that it's able to manage those risks that it has taken on. Next slide, please. You can make the best use of mini-perms. At the moment, because of the requirement that the banks for shorter terms, they're looking at these mini-perms. So 3 to 5 years after completion of construction, banks are likely to increase their margins and have a cash sweep, which is a soft mini-perm, or there will be compulsory refinancing and a default if it does not occur, which is a hard mini-perm. Now, that's pretty tough on the provider, on the contractor, because if they can't find refinancing, they're in default with their bank, so the whole thing is likely to collapse. These increase the risk of refinancing for the bidders, obviously. However, in practice, the authority will often bear the risk of increased margins as they are embedded into the base case financial model. So it's important to ensure that the authority should ensure that refinancing risk is underwritten by the sponsors, that bidders' refinancing assumptions are transparent and realistic, and that refinancing will give a significant downside. And there should also be a plan for mitigation. So it's a proactive approach by the public sector. They've got to make sure that they know exactly how the bidder has put its financial package together. Refinancing benefits above that assumed in the base case should be shared on an equitable basis, i.e. the authority should get most of it. In the UK standard model, it is now 70% to the public sector and 30% to the private sector on refinancing. And again, that model needs to be looked at very, very closely by the public sector to make sure it's right. Next slide, please. There could be a requirement for higher project ratings. Currently, PPPs are around triple B rating, I believe. I'm not a financial expert. But by lowering debt to equity ratios and getting better completion undertakings by sponsors, this could be improved and allow access to the unwrapped bond market. So it's really a question of removing some of the risk to get a better credit rating. There could be an increase in multilateral lending. The presence of multilaterals in funding a project will often act as a catalyst for commercial lenders, particularly where multilaterals take the first hit if there's any problems. I was in Washington 2 weeks ago with the World Bank and IFC, and they told me that as soon as they offer to guarantee a project, even only 5%, all of the commercial lenders will immediately pile in and offer lending after it. So it's the actual World Bank name that is important, and it gives a great deal of comfort to the commercial banks when they're looking at lending. I then asked him, has there ever been a default? And for all of the projects that they have guaranteed, there has never, ever been a default. They've always got their money back, or they've never paid the guarantee. So, interesting lesson. Can we have the next slide, please? Stimulate the unwrapped bond market. Lower gearing by providing junior debt from public funding. Again, an element of public sector input to enable this to take off. Revive the monoline model, which was very popular before the credit crunch, where the guarantor acting as a principal investor provides a wrap against project risks, enhancing bond to the level of the guarantor's rating. That worked very well. Not now. It doesn't exist now. Develop debt funds. This could transform standard institutional funding into project debt, which could be lent to project SPVs, with the fund offering due diligence and monitoring service to the lending institution, thus bringing more institutions into the infrastructure market. That has echoes of the packaging of mortgages, I'm afraid, which was one of the major causes of the original credit crunch, but if it's done properly, it could work. Next slide, please. Simply upfront government payments. Capital contribution, used often for payment of revenue. For instance, in the UK, PFI credits used to be given, and the authority was able either to put that into the project directly to reduce the total overall capital requirement, and therefore the lowering their unitary charge, or they can use it as a revenue. But if you're going to use it to reduce the capital, when will it be paid? If it's up front during the construction, it reduces the risk to the provider, but increases the risk to the authority. And this is one of the problems that I experienced when I was working on a canal PPP in France a couple of years ago, where there's 1.5 billion euros of money was being put in by the public sector, and they were looking at putting it in up front. Now, if the private sector failed to construct the canal properly and the whole thing collapsed, they may be left with a valueless project and a hole in their pocket of 1.5 billion euros. So you've got to actually look at clever ways of injecting that capital as and when the project is progressing. Provide public sector funding guaranteed by the private sector. But this increases the risk to the public sector and reduces public sector funds available for other projects. So some of the advantages of PPP gearing is lost. So again, it slightly swings and roundabouts on that one. Provide co-lending facilities so that if the project suffers from a funding shortfall, the authority can fill the syndication gap. So if you've got, say, 3 banks, in Trevor's case, willing to lend 90 million as the capital contribution, so you had a 10 million shortfall, there could be some element of public funding stepping in for that final 10 million, even though it's temporary, so until permanent commercial funding can be found. Next slide, please. We've discussed this one already. Simply provide guarantees. Either direct guarantees, which reduce the lender's exposure to project risks and thus increase their appetite for the project, or indirect guarantees, of which there are 3 types: underpinning, where financing is supported by the authority by favourable treatment of specific issues, e.g. compensation on termination. So it may be that compensation on termination is paid 100%, rather than in the case of the UK, where it's actually calculated on the actual market value of the contract. So that gives a great element of security to lenders to make it more favourable for them to lend. Sub-sovereign guarantees, where the state guarantees the financial obligations of a local authority or municipality. Here, it increases the credit rating of the project simply by having a state backing rather than just one local authority. So a much bigger financial weight is added to it. And then refinancing guarantees, which should only be for costs other than due to performance of the contract. So if they can't refinance because they have failed to perform properly, i.e. that project is not as valued as it should be, then those guarantees should not be applied, because obviously it is not good PPP practice for the public sector to bail out the private sector when it is in default, effectively. Next slide, please. So, just quickly, what are other countries doing? Trevor's already touched on the United Kingdom. It's currently reviewing its adherence to the private finance initiative, with a view to implementing a new form of procurement. I think there's been a term, smart PFI, which implies that up until now we've had dumb PFI. I don't know. There's just recently a new parliamentary select committee paper come out, which has criticisms of PFIs as they are. One of the criticisms is the lack of experience of the public sector implementers, because they tend to do only one project, whereas the private sector are constantly doing projects, so they're much more experienced and much more understanding of the risks and how to negotiate these things. But also there are concerns over the cost of borrowing. Obviously, it is much higher than the public sector borrowing, so how do we deal with that? One of the ways of dealing with that is the use of what is termed prudential borrowing in the UK. This is effectively borrowing from the central government by local authorities at public sector interest rates. And that money is then lent to the private sector. So you have the concept of public-private finance initiative, which is a bit bizarre. But you have to be very careful, because obviously when the public sector is funding, a large element of the risk transfers back to them, because if it goes wrong, they're the ones that have put the money in. So you have to be very wary as public sector in dealing with that particular risk and how to manage it. Next slide, please. And in France, the Plan de Relance, the implementation of a government guarantee for all bank loans taken out for PPPs. So basically the state is guaranteeing any of those loans, which gives a great comfort to any funder and makes it much more likely for them to fund. There are also special tax allowances for PPPs. Government is also providing advances to banks for the greater part of the loan to a PPP SPV, which therefore enables the bank to pass on the lower public sector interest rate, a bit like the UK prudential model, but slightly different. Government now also allow PPPs to be signed on the basis of adjustable financing, enabling the project to proceed on the basis of government advances prior to finalising deals with the bank. And this is specifically to deal with the issue of the difficulty of getting banks on board with these projects. So you can actually go ahead, notwithstanding that you have not got all of your commercial banks lined up. Next slide, please. So in conclusion, the worldwide infrastructure deficit runs into trillions of dollars, and that's now, without all of the infrastructure that is going to be required into the future. States simply do not have the capital to deal with that deficit. They have not got the money. So the only way of dealing with it is to get private finance in some way or other. Without adequate infrastructure, the social and economic consequences can be very grave to any country. I've seen some of the countries that I've worked in with virtually no infrastructure, and you can see just how difficult it is to get the economy moving on that score. Mongolia is one of my favourite examples where there are virtually no roads. There are, however, natural resources. There's a lot of copper, gold, etc. But how do you get it out of a country with no transport? You have to have infrastructure in order to build your economy. Private funding is therefore vital. So whilst it's now much more difficult to secure financing for projects, it isn't impossible, but the mechanisms exist to deal with this, although it may require more input and understanding from the procuring authorities in this buyer's market. And that's it. Next slide. Thank you very much. Are there any questions?
Спасибо большое, Энтони.
Thank you very much, Anthony, for your very interesting presentation concerning your experience. In this connection, I have some specific questions. Which probably are not just suitable for this type of discussion, because otherwise that will be sort of consulting. However, you gave so many details concerning the situation of possible guarantees that I'm forced to ask a question which at the city administration is the most debatable question when we discussed any project, any PPP project. You said that there are several types of guarantees, direct and indirect guarantees, which naturally increase the appetites of the funders of the project. But we doubt that why do we need PPP if the state directly or indirectly in whatever way would guarantee a 100% repayment of the funds invested by the banks? Can you answer this question?
You may not, but on the other hand, you may be guaranteeing it, but you're not actually paying it. That's really the difference.
Нет, конечно, одно дело гарантировать, другое дело давать.
One thing to guarantee and the other thing to give money, but nevertheless, if eventually the risks not of the project default are not incurred by the person who gives money, but by the person who guarantees, why not having a direct state order?
If it is entirely guaranteed, I would agree with you, yes. However, these are not full guarantees generally, so it will depend on the project specifics, really. So you need to address the specific issues that give funders concern in order to enable them to come in to actually fund. So I wouldn't just say, oh yes, you're fine to do whatever you like and we'll pay for it. That wouldn't work because it would destroy the fundamental concepts of the structure anyway.
Тогда еще один такой же вопрос.
But then another question. In your opinion, is there a possibility for transactions in the Russian Federation of not 100% guarantee on major, for instance, road or highway projects? Or do you think that Russia is not a country where it would be possible to transfer at least a part of risk of the project default to the financing organizations?
I think it's probably more difficult in Russia because the banks are rather more wary of government actions over here than they are, say, in Western Europe. However, it will depend very much on how attractive the project is and what sort of guarantees, I mean, if you've got bilateral investment treaties and that sort of thing, which you have, then there should be the possibility of dealing with it in that way. So, yes, it is going to be a lot more difficult, but there's no reason why it shouldn't happen.
Спасибо большое, Энтони, действительно.
Thank you very much, Anthony, for your very valuable consultation. We always carry on the discussions at the administration concerning each particular project, and we always have difficulties, but nevertheless, as a vector of development of this infrastructure in St. Petersburg, PPP is a mechanism which has the most advanced position due to the advantages and positive motivational effects that are created by the PPP mechanism for real investment of money into infrastructure, where nowhere previously, for instance, 10 years private funds were invested. It was always previously financed by the budget. Dear colleagues, do you have any questions, opinions? I suggest that you should more actively participate in the discussion. High School of Economics, Vasilieva Svetlana, Associate Professor. I have a question to Vladislav, even two questions. First, you said that at the initial stage of a legal regulation of PPP in Russia, the model of concluding such agreement was rather stringent. For instance, the process of negotiation was not provided for a concession agreement. Yes, concession agreement. Now this is not the case. The negotiations are possible, but I'm sure that then and now, in addition to legal negotiatory process, there is also an informal process of negotiation, even if the negotiations were not provided for formally. Informal negotiations always take place. What do you think? Legalization of the negotiatory process, did it bring down the level of informal negotiations in this sphere? As to informal negotiations, I do not mean the negative or corruption negotiations. All of us understand that we have to meet and to carefully discuss some matters with potential subjects. That is a long-term and difficult negotiation. And secondly, we have accumulated significant experience of PPP agreements in different spheres. I'm speaking about Russia. What do you think? Is there a trend of unification, the legal forms of PPP agreements depending on the spheres of public relations in which PPP is concluded? For instance, for waste recycling, water treatment, these are concessions, and for road construction as well. For Pulkovo Airport, that is a very complicated act, including agreements and acts of the authorities. For some other spheres that might be purely investment agreements, are there any tendencies of stable legal forms of PPP projects in Russia? Thank you for your questions. As to the process of negotiations, you are quite right. Any project initially requires serious development, and you are quite right that there is no negative connotation related to negotiations. However, when the administration, irrespective of the level, prepares a project, it has to consult the potential investors, because if it prepares the project proceeding from its own notion about the world and life, and if the administration has no money to full-fledged consultants, and it doesn't understand how these questions are solved on a standard basis in global experience, but attracts the foreign concessions, that is a direct road to the failure of the project. These negotiations take place. They are necessary in order to correctly develop the tender documents, and an option of a a version of the agreement that will be signed because it is a part of the tender documents. The problem was as follows, and is as follows. At the previous level of our legislative process in some concession agreements, there was a stringently approved form of agreement. Whether you have negotiations or not, many questions could not be changed. There was a special form, names, addresses were given, interest rates or some other technical conditions which are always reflected in tender documents, and that's all. You have no possibility to change the agreement. The principal difference, for instance, as for Pulkovo projects, these were two stages of negotiation. One stage when you prepare the documents and collect the information on the market, you consult the specialists involved in the project and those who might be potentially involved or those who will never be involved because they don't have the resource or possibility, but you get the expert opinion concerning the conditions of project implementation to be taken into account when it is implemented. And the second part are negotiations with the winner of the competition, and there are two components. There are stringent requirements of the competition documents which you cannot change, and any change will result in a risk of contesting the results of the competition. And there are some things in a more flexible sphere that will never be contested, though this is a process of negotiation. Though they may be diverse, they make it possible for you to reach the necessary flexibility for the project implementation. You know that unfortunately the negotiations might fail, and then our competitive procedure involves the possibility of having negotiations with the second part of the competition. But globally, this exists not to make the project less transparent or more flexible in that situation. It just exists for making it successful, because if the parties initially agree on the possible or reasonable means of attaining the results, they will be more successful in implementing the final version of project, and Pulkovo project confirms it fully. The second question concerning unification. Yes, unification is underway. It is carried on a continuous basis. We can say that initially we proceeded from the stringently recorded agreement, then we pass on to flexibility, then we'll pass on from more flexibility to a standard decision. It is at the level of PPP legislation. Initially, Petersburg law was the basis which were used by the regions to adopt their legislative documents. There is a commissioner under the State Duma dealing with PPP project. It also developed a model agreement and model law on PPP that is not just a law, but that covered the territory of many entities of the Russian Federation that can use it. Undoubtedly, the process of accumulation of the experience would result in the following. Some problems will be solved in a more unified way. On the other hand, the problems are different. Financing in different regions are different in their essence. And I think that it would be, we need rigidness and flexibility that will be a response to the question concerning unification. We cannot foresee everything. But if we're speaking about regions, they have to understand how this works. They have to receive some model documents. Otherwise, each time we'll meet the same wall. Being a moderator, I would also like to add, as to the negotiations, this is a legal, technological question. What do I need? The only law that makes it possible to carry out negotiations after you reveal the winner is Law 115. The Civil Code doesn't say anything, though there are certain articles on the competition. Federal Law 94 doesn't state anything. What does it mean that we don't have a right to negotiations? You have a winner, the document, agreement is attached to the competitive document, there is address, name and signature, and then a comma to say nothing of such issues as cancellation agreement about penalties and guarantees, is a direct road to the court of law from the participants of the competition, from the prosecutors, from the Federal Anti-Monopoly Service. That is a major risk which all the consultants can always reveal. And about the 20 risk points, this item will also be revealed, and the banks will also reveal something. Better you do it next time or elsewhere. So a very important advantage of law 150, and that it introduced this stage of negotiation and it is not related with corruption scheme. As to unification, Vlad shows his usual optimism. I do not believe in unification in the next 10 years.
There are examples, simple PFI projects here that we can have many of them. Can simply double them. Yeah, because for a couple of years we've been working on them. The rest of the project, they are unique. They're unique. It is impossible to standardize that because they have a unique payment mechanisms and structure of project. For example, a toll road. What can be done? Okay, it can be like M10, highway M10, like a federal road. Okay, whether there's one person driving there or 1 million, so it will be all your problem. So no questions to the Russian Federation. At the other extreme, it is a life cycle project, performance-based project. So you will be paid, you'll be compensated, you'll get your revenues. It's because there is this demand risk coverage. So, and this could be built in an open space in the middle of nowhere, and it will still work. Or there can be a revenue guarantee mechanism. So if the revenue is below a certain level, then it is compensated, but if it is above a certain level, then this profit is shared. So how can we identify a single approach? No, it is impossible yet. That is why all these projects are unique. We speak about the same thing, the same project is a toll road in all of these, but it is so different. So I believe every situation is unique. More questions?
I am still to be convinced that these new structures have to be created, and I don't think it is a question of using the market on the one hand, either the market or state and municipal mechanisms on the other. It's not a question of these two, because you can use the market and market mechanisms without entering into PPP agreements. I refer to a new prison we were building in Iceland now, a new big prison. Now, first we design the prison. That goes on the market, and we take the lowest and best bid. Then we construct the prison. That also goes on the market, and it's private contractors which will build the prison. The same goes for the roads. The road system is public, but all new constructions are operated by or constructed by private contractors after going on the market, where we take the lowest bid. But what we don't want to do is to introduce profit mechanisms into basic services like the prisons, like water services, sewage, etc. And this is the division line. And this has also to do with flexibility into the future. We don't want to be in the hands of contractors for many years into the future. So it's not a question of either wanting to use market mechanisms or not. It's not a question of that, in my mind. It's a question of entering into these projects where society is in the hands of private companies for years to come. That is my criticism.
У нас нет проектов с тюрьмами, поэтому я бы передал этот вопрос нашим иностранным коллегам.
We don't have any prison projects, so I'd like to ask our foreign colleagues to speak about that, comment on this.
Yes, you can design your own projects, and yes, you can go out and do traditional construction, but the problem there is that if that design is not correct or does not suit what your requirements are, i.e. as if you did an output specification rather than input specification, you will take that risk. And if you will also take the risk of construction overruns and both cost and time overruns. And Alexei pointed out earlier just what a big difference there is where you put the risk on the private sector. It goes to 70 to 80% from 30% cost and time overruns. So it's a huge difference. And my final point is that where you remove the obligation to maintain an asset from the obligation to build it, you're also removing the obligation to build it to reduce its life cycle costs over its lifetime. And that's shown significant benefits worldwide, because where a contractor has to maintain something for a period of time, then they are incentivized to make sure that the way they build it will lead to the lowest cost maintenance over the whole period. So you get a better quality of infrastructure generally, and you also don't get the sort of disputes that you are characterized by traditional procurement, where they go in at the lowest cost bid and then rely on making their profit by making claims against the procuring authority as they go through construction, which I've seen quite a lot of times. So it swings and roundabouts again. If you want to take all of those risks and those costs, that's fine, but you will probably end up with a lower quality of infrastructure and possibly deteriorating infrastructure, because another characteristic about the public sector is that once they have infrastructure, they tend not to maintain it. Maintenance is always the thing that gets hit during times of economic difficulties. The first thing they'll do is stop maintaining their infrastructure. And as soon as they do that, the infrastructure starts to deteriorate, and then it's a lot more expensive to actually get it up to the level that you would normally expect in the future. So it actually ends up being more expensive, but hopefully by that time the politicians think someone else will be in power.
I disagree with you on almost all points.
I thought you might.
У меня нет примера, я просто думаю, может быть, самый такой...
I'm thinking, maybe the most positive way to convince. I don't have any prison projects. We haven't been doing that yet. But I have an example with a toll road. We have a ring road around St. Petersburg. It was financed by the public money, and it is maintained and operated using the budget funds. And last winter, there were repair works. And again, the idea was that public money would be used. And what happened? So the whole section was closed completely, and then they did repair works very quickly. Right. The time was very short, but that was an enormous difficulty because drivers couldn't enter or leave that road in that section. I was trying to imagine what could happen if it were a toll road using a PPP model. Private sector would depend on the traffic, of course, if it were a toll road, because every driver pays a certain amount every day, every time, and I could imagine what would happen. They would still leave half of the road open, or maybe they would do those repair works at night. The effect would be the same. So And what about you as a taxpayer or as a user? What you would choose? The first scenario or the second? And I believe the same can be found about school or prison projects. Again, I'll repeat. Most important reason why PPP model is better is a motivational factor, because the private sector and the public sector, they have different motivation. More questions, please? Yeah, or otherwise we'll deal with the more examples. No more questions. I believe that we demonstrated by finishing up this discussion earlier, we demonstrated how efficient we are in this area, and this topic made us quite efficient. Thank you very much for you all who participated in this panel discussion, and I myself, I enjoyed this. I learned a lot, and all this information has been very useful, and I believe we will continue discussing PPP area, and we will try to learn lessons provided by the international experience, and maybe, and Trevor mentioned that, I never actually heard about it, maybe we can use our financing, available liquidity from Russia, in foreign projects as well. Thank you very much.